Good morning, everyone. We're going to get started. I'm Jim Holloway, intellectual property partner with Baker McKenzie in Toronto, and welcome. And thank you for joining today's webinar, which discusses litigating designs in North America, in the US and Canada. Before we jump in, I've got a couple of quick housekeeping notes. Perhaps we can bring those up. If you do have any questions, please use the Q&A box at the bottom of your screen. We'll answer those questions after the presentation and hope to get to all of them. If we can't, please get in touch with us after the webinar and we'll certainly do our best to give you an answer. Along the way, we're going to flash 4 polling questions to get some feedback from all of you on your thoughts and impressions. Please make sure to respond within 20 to 30 seconds, and then we'll flash the answers up on the screen. At the end, we'll also put up the US CLE code and the instructions to get your CLE credit will be emailed out after the webinar, along with our slides and a recording of today's meeting. Finally, the session is going to be recorded, and as I said, the webinar materials will be shared with you after the event. Moving on. I'm joined today by my friends and colleagues from the US, McKenzie and Voss, who will discuss litigating designs from a US perspective. And of course, I'll talk about the Canadian perspective at the end. Here's what we're going to cover: 4 points: the protection of designs generally, pre-litigation considerations, evidentiary issues in enforcement, and then I'll close up talking a little bit about litigating designs in Canada. First polling question before we turn things over to my US colleagues. How does your company protect designs and imagery? And there are 4 choices there. If you could select one and hit submit, we'll see what people have to say. Interesting, and that probably will align with some of the comments and thoughts we have about design litigation as we move ahead. Next question. Does your company use any of the 3 choices up there to protect or enforce its rights? We may be having a technical issue with that polling question. Let's see if we can bring up the results. I think we did. So let's just move right along. So Voss, over to you to talk about US design patent enforcement.
Thanks, Jim. And my section here is on the preparation and prosecution of design patents before we launch into the litigation side, which will be covered by McKenzie. So design patents offer a great alternative to more traditional methods of using IP to protect imagery and designs like trademark, trade dress, and copyright. Design patents protect the ornamental or aesthetic aspects of articles of manufacture, i.e. physical objects. So when we're thinking about how we can use these design patents, we're not looking at functional aspects. We're thinking about how the object looks. For example, what is the shape? What are the proportions of the various edges or sides of this object? What kind of surface ornamentation do we have? Do we have some designs? Do we have ridges? Or any combination of these aspects? So we're looking at ornamental aspects, not functional aspects. When we're thinking about what the subject of the design patent is, we're looking at this article of manufacture, which can be interpreted quite broadly. Traditionally, we're thinking about physical objects, but they could even be fleeting articles like a water fountain. Or later on, I'll be talking about designs on a display screen. They are protectable as well using design patents. Next slide, please. Okay, so when we're thinking about how we're going to go ahead and protect our article of manufacture with design patents, we've got to look at features that are visible to a user or to a viewer. If the features are not visible and cannot be displayed using the various views that we will depict in this design patent application, those are not protectable. Next slide, please. Okay, so a couple of points I want to make with design patents. When we're talking about utility patents, we can come up with an umbrella claim that protects various embodiments of our invention. But with design patents, that's a lot tougher to do. So if we've got various embodiments, we kind of have to protect each embodiment on its own. A few years ago, we had a client that wanted to protect a ladder. And on the utility patent side, we were able to protect a ladder that has, different numbers of legs using the same utility patent claim. But when it came to design patent, protecting those same embodiments of ladders with design patents, we needed to have a different design patent for a 3-legged ladder and a different one for a 4-legged ladder. And when we present all these embodiments in a single patent application, it is highly likely that the patent office will restrict out your patent application and essentially tell you that you will have to pursue one of these embodiments at a time, and the later ones can be pursued either serially or simultaneously with divisional patent applications. So you only get one bite of the apple at a time. So it's kind of important to be picky with regard to the embodiments that you are pursuing. Additionally, we need to have a proper set of views for each of these various embodiments. And the views would be, and the proper set would include a top view, bottom view, both side views, front and back views, and then a perspective view. So just that's always important to remember. Next slide, please. Okay, so just like with utility patents, your design inventions must also be novel and non-obvious. And I'll go through the definitions of each of these two, but in general, I will say when compared to utility patents, the standards for achieving novelty and non-obviousness in designs is much lower, which is reflective in the allowance rate for design applications, which is usually over 90%. And many a time you will get your design patent issued without any office actions. Next slide, please. Okay, so with novelty, the prior art must be identical in all material respects. So it's essentially got to be a carbon copy of your design invention, the prior art that is, of your design invention in all respects. That means every single view must be the same, and the perspective view, it must look the same as well. That's a very difficult standard to achieve. Next slide, please. So with obviousness, you must look at the design from the perspective of a designer with ordinary skill. And here, I just wanted to add a practical point with regard to obviousness without getting into how it's defined under the design patent laws. In design, when prosecuting design patents, non-obviousness is much easier to achieve when compared to utility patents. So, with the allowance rate, as I indicated, being over 90%, as long as you've got a view of your design where you're not being too greedy with the coverage that you're expecting. So it's not all dotted lines, but includes some solid lines or a good amount of solid lines that capture the design of your article, it's likely that it will be non-obvious. Next slide, please. Okay, just like with all patents, public use and on-sale bars apply to design patents, which means it must not have been the subject of a commercial offer for more than a year before your design patent filing date, and it must not have been used in public more than 1 year before your design filing date, before your design patent application filing date. These are always good questions to ask upfront to make sure that you are meeting these requirements. Next slide, please. Okay, so this is interesting. Patenting software with design patents, it's become much more of a thing over the past several years, especially since the Apple-Samsung case. And we've had many clients inquire about this coverage. So you can essentially protect the look and feel of your mobile application or your software application as it appears on screen. This is extremely important. And I'll give you a practical example. Last year, right at the advent of the pandemic, Zoom obviously became a tool that started becoming a ubiquitous tool. And many copycats emerged, especially outside of the US. And there was this one app that I came across it showed up on my LinkedIn feed. It was released in India. And when you looked at the user interfaces, they were almost dead-ons for what Zoom had, screen by screen by screen. Now, unfortunately, Zoom did not have any design patents, especially international design patents protecting the user interfaces. But if they did, that would have been an avenue to seek some sort of relief. But the reason why this is important is that user interfaces are very, very important with regard to apps. Let's just say you've got, your Instagram app today. For someone to come up with the same idea, but on a different interface, it's really difficult to build a user interface, to build a user base. But if you are able to copy what has already been successful, it's a lot easier if your app looks and feels the same to build that same user base. So design patents are critical for software clients, and as practitioners, it behooves us to provide that option to all of our clients, and we have done so over the past few years. And I think I have a polling question here to finish off my section. So how often does your company use FTO or freedom to operate services? Let's see what we have here. Okay, a few times a year, numerous times a year. That's good to know. Obviously, I think it's a good business decision to see what's out there before releasing your product in the market to reduce your risk. So I'm glad to see that. And with that, I will pass it on to my colleague, Mackenzie, to proceed with the next portion of this presentation.
Thank you, Vas. So we just heard about some strategies for design protection, in particular with an eye toward enforcing those design rights. And now we're going to pivot a little bit and discuss some pre-litigation considerations, both in the offensive and defensive contexts. And in both of these contexts, we'll take a look at competitor monitoring, including design patent searches, and also some alternatives to consider in the pre-litigation stage. We'll also discuss preliminary injunctions. So whether you're seeking to enforce your design rights or to avoid design patent infringement, design patent searches are a quite useful tool in keeping competitors' actions on the radar. So for example, in the defensive context, when you search for competitors' design patents, that can be useful because, or I guess useful even as they are in the traditional patent space, because it allows your company to be more aware of your competitors' issued patents and help your company understand what your competitors are doing. In doing so, this allows you to have an understanding of what design rights your competitors have to help your company avoid potential infringement. And depending on the context and the business need, there are really several kinds of design searches that can be beneficial. So first, we're going to look at patent watching searches. This can be quite useful in the design space as they are in the utility patent space. What this means is you're looking and running searches around, for example, relevant industries. You may run targeted searches on specific competitors or companies of concern. You can run searches on specific fields of technology, or really any context or factor can be used to run these searches, just depending on the needs of the business and what the company might be concerned about. And these patent watching searches allow your company to just stay on top of new technological developments, potential infringement risks, as well as what your competitors are doing in the market, and whether or not they might be patenting designs that your company has already developed on one hand or has already put into the marketplace. Freedom to operate searches are another kind of search that you can use in the design patent litigation space. These can also be called patent infringement searches. These are used for design patents in a similar way that they're used for utility patents. And these searches can show you, for example, what type of designs might exist that are similar to your existing product designs and help your company strategize on how to adapt your own product designs moving forward to make sure that you're minimizing risk of infringement. It also allows your company to kind of holistically and objectively weigh the level of infringement risk on one hand with how much you might be willing to adapt the product design and the costs associated with that on the other hand. As a result, these are best considered quite early on in the development of a product design so that the company can be properly informed of risks and won't have to adapt a design later in the process when it's a bit more expensive and risk having to make a tough decision balancing, incurring some kind of redesign costs versus running with a higher risk product design. Next slide, please. Businesses can also use kind of a variety of strategies on the front end before releasing a newly designed product to minimize risk of design infringement allegations. So in addition to patent searches, which we just discussed, or in supplement to those patent searches, there are some other strategies that you can use. One is designing around. And so if there are similar designs in the market that your business is aware of, you may consider adapting your product design so that it's not as similar to a competitor design that's already on the market. Distinguishing your own product design from other known product designs can help you prevent or minimize future potential claims that your design is infringing on another company's design rights. As another layer, those patent searches that we mentioned a minute ago, those can inform your design around strategy, you can uncover design patents that you may want to avoid in litigation on one hand, but you can also uncover prior art, which may help you have some confidence that you would have some defensive cover in case you ultimately ended up involved in a litigation. And I think Boss already touched on, if it infringes, if it's later, it invalidates it if before. So if your product design is closer to a prior art design than it is to the competitor's design patent, that's a much lower risk product design. You may also, in the context of designing around, consider opinions or advice of counsel on those design arounds to help the company just feel confident about its approach and the design that it landed on, and also to minimize damages in the event that you are sued. Having advice of counsel or having an opinion of counsel can help you avoid a conclusion of willfulness or a finding of willfulness in a district court litigation in the event that you are unfortunately found to infringe a design patent. And last, I just wanted to briefly mention purchasing or licensing design rights. If you believe that your product may be infringing on someone else's design, but the company is resistant to adapting the design or designing around, you may have the option to purchase the design rights or to license those design rights and avoid the litigation risk outright with respect to at least those rights that you know about. There are a variety of ways and considerations in doing this, which will vary really depending on the specific context, but it's something that should at least be considered at the outset. Next slide, please. Another really early defensive consideration, and this is a consideration that you can make in the early stages of a litigation, or even if you haven't been sued, but you think there's a possibility that you want to be, that you may be sued. You can challenge the validity of the design patent at the patent office itself. And so I guess in a way, it's kind of the best defense is a good offense. Just go straight after the validity of the patent at the PTO and see if you can knock it out. For those who are not familiar, these proceedings are administrative proceedings, so there's no jury. They're very sophisticated technical judges. It's a short timeline to resolution, and there's very limited discovery. Most commonly, these are in the form of inter partes review, IPR petitions. And basically, the IPR process is spread out over about 15 months, and it has a quite high rate of success in general. So companies often view the process favorably in view of its success to cost ratio. There are some upfront costs involved, which are not insubstantial. So this would include filing fees at the USPTO, fees associated with searching for prior art, and also preparing the petition. But in view of the limited discovery and the quick timeline to resolution, often money can be saved in the long run as compared to a full-blown federal court litigation to assess validity of the design patent. Depending on the court, a petition filed at the USPTO can serve as a basis for requesting a stay if you're in a co-pending litigation, which allows for additional cost savings. Post-grant review, or PGR, can also be used. There are actually more grounds available and more types of prior art available for challenging patents, but the time period for challenging the patent is more limited. In fact, is limited to about 9 months after issuance. So if you're beyond that time period, you simply can't file a PGR. So this slide shows some statistics for how often design patents are addressed really in any type of petition for fiscal year 2020 at the PTO. And as you can see, designs are actually not often the subject of these proceedings. On one hand, this may suggest that design patents, the challenging design patents at the PTAB is not appreciated by many practitioners. But on the other hand, these petitions with respect to design patents in particular are less likely to be instituted than utility patent petitions. And so it's possible that the slightly lower institution rate is causing folks to pause there. Bringing an IPR and PGR, though, could still be an effective strategy in the design context, even if you're not ultimately successful. because the patentee who is trying to preserve their rights, or the PTAB judges, they may rely on a very narrow scope of the design right itself or of the claimed design to avoid prior art in preserving the design validity. And that can be helpful in defending a litigation down the line. Next slide, please. So we spoke about a few defensive considerations just now. Let's turn a bit to enforcement. High level, I think enforcement can seem overwhelming. It's hard to feel confident that you're aware of every potential infringement out there, and there are always budget constraints to think about. So how do you protect your company's design rights, and how do you approach monitoring the market in a methodical and strategic manner? So this really boils down to a few considerations, which is, who are you going to monitor? What are you going to monitor, and how? And starting with the who, you can cast a very wide net, including competitors, partners, and vendors, but that can quickly get out of hand with respect to budget. So you may want to think about prioritizing and narrowing on the front end with respect to who you're monitoring to make sure that you're effectively and efficiently monitoring the most important targets in that regard. Next slide, please. So in terms of monitoring, you can use patent watching searches. So I mentioned design patent searches and the benefits from a defensive perspective a few minutes ago, but searches can also be used offensively. And patent searches can be used as an important clue into your competitors' product designs, even though a company's patents are not necessarily representative of the company's actual products and services. And also it's worth noting that your patent publications can actually lag the filing time by about 18 months. And so there can be a delay there in understanding what your competitors are doing. So it's good to also consider other types of searching, for example, internet research, trade shows, market research, or engaging monetary services or monitoring services, third-party services to help you monitor the market and understand what's going on. After a pre-suit investigation, you may want to send a cease and desist letter. This is where you send a letter to a competitor whom you believe to be infringing on your rights. But from the US side, you have to just be careful because depending on how those letters are worded, it can give rise to a declaratory judgment action. And as the patent rights holder, you always want to be in charge of venue and not trying to defend a declaratory judgment in a form that's maybe not as favorable to you. Again, as the rights holder, if you're willing to sell or license your rights, you may consider that at the outset before suing. Licensing the rights can sometimes be a lot more helpful to keep parties on good terms where you probably wouldn't be on such good terms in the event of litigation. So it's always worth at least pausing to consider that. In terms of preliminary injunctions, while they can be difficult to obtain in the design patent space, they do offer a higher likelihood of success in the design space as compared to utility patent litigation. Design patents are also less likely to be invalidated during litigation than utility patents. And so there's a lot of upside to pursuing infringement cases based on design patents. The same test, the 4-step test for receiving an injunction applies in the design patent context, but the irreparable harm element is often the most difficult to establish with respect to design patents because some courts have shown that the harm must be shown to have been caused by that specific infringement. And so in view of this, consumer surveys are often important for getting a preliminary injunction as you need it to paint a picture of a consumer really buying a product because of the patented design in order to kind of establish that you qualify for the preliminary injunction. There are some important strategic considerations when seeking a preliminary injunction with a design patent. And it's kind of an interesting paradox because on one hand, by protecting the most important and key elements of the design only, you increase your chances of a finding of infringement and decrease the chances of invalidity ultimately in the litigation at the end of the day. However, that approach will actually decrease the chances of getting an injunction in the early stages because it's harder to establish that your own product necessarily embodies the claimed design. That showing is easier if the design right is broader. And this showing that is necessary for the preliminary injunction stage is not a requirement ultimately for proving infringement at the end of the day. So it's kind of a balance there. And I think the way to consider it is to, have patents of varying scope with respect to your designs and make sure you have some broad and some narrow to allow you to be, effective in the litigation context, both at the preliminary stage and ultimately. Next slide, please. So a few other brief pointers. It's worth considering the US ITC. You can bring design patent litigation there, and for the same reasons it's favorable in the utility context, it's also worth considering in the design patent context. And additionally, you want to think about, in view of the high cost of US litigation, you may want to consider non-US design litigation because infringement in the US is often analogous to infringement in other countries. And if you're thinking about the supply chain around the world, there may be a very cost-effective way to, stop infringement at the source or further up in the supply chain in a less expensive jurisdiction than in the US. So that's always worth considering. I think we have a quick polling question. So which of these do you rely on heavily when litigating designs? Expert reports, consumer market surveys, both or neither? I'll just give you about 15 seconds. Okay, can you close the poll, please? Looks like we may have had some technical issues with that one, but we'll go ahead and move forward. But if anything, that gives you a preview to what we're going to talk about briefly in the next section. So in terms of evidentiary considerations, go ahead and go to the next slide. The plaintiff is always trying to show infringement via the ordinary observer test. And that test has been refined over time. But what I wanted to get to today was really how can survey evidence and or expert testimony help the plaintiff on the bringing a design patent litigation establish infringement, or the defendant in establishing non-infringement or invalidity. So if you can skip to the next slide, please. And sorry, one more slide, please. Sorry, next slide. Oh, looks like we have an extra one in there. Apologies. Would you go to the next slide, please? Okay, so survey evidence. So design patent litigation concepts, they are similar to the concepts found in trademark or unfair competition litigation. And so expert reports and market surveys often serve similar purposes in design patent litigation as they do in those other contexts. But they are not as widely respected or as necessary as a form of evidence in the design patent litigation context in the United States. And that has to do with the fact that there's actually a different quantum of proof applying in the design patent infringement context that basically renders these things helpful in some contexts, but not always necessary. And there are several examples, both at the federal circuit as well as in the district courts around the country, holding just that you can, for example, the infringer can make an ordinary observer comparison and be successful in it without necessarily having survey evidence. And the normal applications of, potential motions to strike or motions to exclude that types of evidence and also expert testimony are worth or are equally valid in the design patent litigation context. And so you always have to balance the risk of how strong is the evidence, how good is your expert versus whether it's really necessary to proving it up. In terms of experts, expert evidence can certainly be used in design patent litigation, although they are most commonly used in like very specific areas such as obviousness. And for example, what does a person of ordinary skill in the art know? And also in functionality assessments. So in order to show design patent invalidity, an expert may weigh in on the fact that certain aspects of the claim are merely functional and not ornamental. So those are the two contexts that typically expert evidence can be most helpful in. But again, design patents really live in a space where expert reports and surveys can be useful, but are not necessary. And so in preparing your litigation strategy, it's important to really assess what the key issues in the case will be and weigh the use of an expert and empirical evidence, because there's really no magic bullet in picking one or the other as a main point of evidence in each and every case. So with that, I want to turn it over to Jim for his thoughts on litigating designs in Canada.
Thanks, Mackenzie, and thanks, Voss. The situation in Canada around designs, infringement, and the evidence needed to prove or disprove a case are similar. So I'll try not to repeat those similarities. The process is a bit different. These cases up in Canada are tried by judges alone, and the discovery process is far, far more limited, which usually means the cases are far less expensive for clients. And in Canada, the successful party, be it the rights holder or the defendant, is typically awarded some share of its legal costs at the end of the proceeding. Designs in Canada are protected under this short and discrete piece of legislation called the Industrial Design Act, but can also be protected via trade dress and passing off claims where the design is distinctive, and I'll talk a little bit about that. And sometimes even still in copyright litigation, although that's now in very limited circumstances only. The law says, this legislation says, that where a design is applied to a useful article and reproduced in quantities of over 50, this is the piece of legislation where you need to find your statutory rights, because the Copyright Act says that the reproduction of that design, even if protected by copyright, and it can be, isn't copyright infringement. So you can have copyright in these ornamental designs, but you can't enforce it under the Copyright Act. You need either a distinctive design that you can enforce via trade dress or passing off litigation, or you need registered rights under this legislation. If you have those rights, protection lasts from 10 years from the date of your registration or 15 years from the filing date. And the definition of design is here very similar to the US. It's visual ornamentation that appeals to the eye. That's what's protected. So in my experience, much of what a client or an industry sees as valuable in an industrial design isn't protected under this legislation, which is limited to visible ornamentation. Next slide. Getting the registration is easy, probably easier than in the US and similar to what it is in other countries. It's not rigorous, and often the only assessment that takes place during the application process is as against other registered designs. So the examiner will look at what's applied for, what's claimed, and then do what in our experience is a pretty limited search against prior art to see whether or not the design should be registered. It gets harder in litigation, and I'll come to that. The rules do now allow for variants to be part of the same application that aren't substantially different from the applied for design. And since 2019, we also allowed divisionals, which can help overcome an objection. For example, if an examiner thinks that two designs or more than one design is being claimed, you can use a divisional to carve off. To be registerable, the design must be novel, as in the US, relative to all prior designs. And that's not the same as what Vass described. there must be a meaningful difference, a substantial difference between the new design and the prior art. That's a higher standard than in copyright litigation. So prior art needn't be identical. The question is substantial similarity, and that's not always picked up in the registration process. Obviousness per se isn't part of the exercise, although it can be brought in implicitly through the originality requirement. Next slide. These are just a few examples of the types of products we've seen protected by industrial designs, and clients are applying for these far more regularly, although there hasn't been a lot of enforcement. In our experience, in our practice, a lot of these applications up in Canada relate to food and packaging for consumer goods. And most recently, and interestingly, we used this to have a case dismissed a little while ago for a client. Jewelry that's produced in sufficient quantities has been brought in to the design protection field too. So copyright claims in jewelry typically can't be enforced anymore, and you need registrations under this legislation. What's clear in our experience is that the more utility a product has, the more useful it is, and the more that utility informs or directs the design, the harder it's going to be to enforce, and the more likely the registration can be successfully challenged, and I'll explain why in a second. Next slide. So this is what constitutes infringement up in Canada, and the court's analysis, which is a very subjective exercise, is based on the overall visual impressions of the protected and infringing products, and whether the offending design does not differ substantially from the registered design. Typically, there's a lot of expert evidence around that, and there could also be consumer surveys. Importantly, as I expect is the case in the US, in the infringement analysis, the court will ignore the features applied to the article that are dictated solely by its function. And even if that's claimed and gets through the registration process, and I'll talk briefly about a case where this happened, that can substantially limit protection and in some cases invalidate the design. As part of this as well, the extent to which the registered design differs from earlier designs, not the infringing design, but earlier designs, prior art, is also taken into account and has become an important part of the infringement analysis. And as I said, in this process, there's less discovery and judges hear the case. If we could move to the next slide, please. So jurisdictionally, these claims can be brought in any court, although practically up in Canada, virtually all of this litigation is done in the federal court because there's a lot more judicial experience with intellectual property in that court. Their decisions are enforceable across the country, and only that court can invalidate and strike a design registration. And importantly, for anyone who's licensing in or out these designs, if you're the licensee, the owner or proprietor of the design has to be a party to the litigation, irrespective of what the license agreement between the parties sets. Next slide. Remedies are pretty similar to what we find in intellectual property cases more generally. Injunctions, damages, or profits, and importantly in Canada, for both parties, some compensation for legal costs. A temporary injunction, a TRO, is very, very difficult to get in Canadian intellectual property, and equally, if not more important in our experience, to get in design infringement cases. Now, you see this little second bullet, this finds its way into our copyright legislation too, and can become a problem in deciding whether to pursue these cases. The law says that an injunction is the only remedy where the defendant didn't know and shouldn't have known that the design was registered. And that comes out of our Copyright Act as well. But you can avoid that trap by marking the product or its packaging with the capital D in a circle and providing the name of the owner's design, and that argument is then taken away from the defendant. If you don't have that, or somebody's dropped the ball along the way, you can still have a trade dress or passing off action if the design is distinctive. Next slide. This is how our courts apply or approach the infringement analysis, and they do it in this order. The first three are really designed to scope out whether the design is valid and what a substantial difference might entail. And the prior art examination here is going to go well beyond what the examiner looked at in deciding whether that design was going to be registered. Much higher level of scrutiny. And also, the court will look hard at the utilitarian functions and the extent to which design features are dictated in whole or in part by those functions, and they can strip away some of the protection that's claimed in the design if they think that those features are dictated by that functionality. So you get through that exercise, generally a fair amount of expert evidence, and in some cases consumer surveys, although the issue isn't consumer confusion. Get through that, the judges will figure out what, if anything, remains to be protected, which would be the novel and non-functional ornamentation. Compare that to the infringing article, and then determine whether there is a substantial difference or not a substantial difference. And again, looking at the few cases we've had in recent years, that's a pretty subjective exercise by the judge. I just wanted to talk briefly and almost lastly about 4 cases that I think are pretty instructive in how these things are playing out in Canada. There haven't been many decisions, many cases that have gone to trial. We have one that's going to be heard shortly. I think that's because small differences matter. These designs are easy to get, hard to enforce. And I think as well, the life cycle of these designs is relevant when companies decide whether or not they want to pursue claims or change their own designs. Milliken was a case that involved a design applied to carpet tiles. And the plaintiff there sued under the Copyright Act, which turned out to be a big mistake. And the judge noted that designs should be protected under the Industrial Design Act, and where they can be, they should be, and only in very limited circumstances can the owner of a design or the author of a design enforce its copyright. Not to say there isn't copyright, but that it can't be enforced. So the case was dismissed in Milliken in that case. In Bodum, which is a very instructive case on prior art and novelty, Bodum sued on designs applied to a double-walled drinking glass, which at first blush looked like a pretty good design. But there was a lot of evidence brought in around prior art, and ultimately its registration was held invalid because its design wasn't viewed as substantially different from the prior art and was a simple variation. And interestingly there, the prior art was closer to the allegedly infringing design than it was to the Bodum design, which the judge found to be very important, if not determinative. So it lost its registration and its case and paid legal costs. In AFX, perhaps the most recent important decision, the plaintiff sued on a design protecting a face shield for helmets. I guess motorcycle helmets or up in Canada in the winter, snowmobile helmets. And it got that design after it failed to get a utility patent and seemingly chose to try to go the design route to hold on to some sort of a monopoly over this particular device. Now, the design was held to be valid in the face of a lot of prior art and claims relating to functionality, but the trial judge, who's our former partner up in Canada, Justice Diner, held that the design wasn't infringed after excluding the utilitarian features from the analysis. In his view, much of what was claimed was largely, if not entirely, driven by the functionality of the shield. And he stripped the protection away from the design as claimed and brought it down to something pretty simple, much less than the plaintiff in that case expected. Probably could have held the design to have been invalid on that basis, but he didn't. And the lesson in that case was that very small differences can be big differences in this litigation, particularly where a product is more utilitarian. So not like a food product, but a device like a face shield or a similar consumer product. The Mission case with SuperTech involved a garden hose protected by a utility patent and a design registration, so which is a good idea. The plaintiff there was able to get registered rights in both the utility and the design. The design was held, though, to be invalid because it was insufficiently original or lacked novelty, and because, again, its features here were driven entirely by its function. And case dismissed, legal costs paid. And I think the lesson there is really stepping back before you get into litigation and asking whether it's worth it. Is there enough value in asserting a monopoly in this particular design? It's nice to have a registration, but it's not always valuable enough to enforce it. And I think the owners of these rights have to approach litigation with their eyes open as to whether or not there's a high risk that design will be held invalid, its case will be dismissed, and it'll pay its other side's legal costs. And if you read that case, it sort of question the logic of bringing that lawsuit, even though those rights were presumed to exist. And in that, the final point on Mission, and there haven't been many cases up in Canada on this issue, but there was a counterclaim which was ultimately successful where the defendant obtained damages because the plaintiff had sent out pretty aggressive demand letters to the defendant's customers saying, if you're going to sell these products, you're going to be infringing our patents, both utility and design. That turned out to be wrong. And the defendant in turn brought an action against the plaintiff, essentially for trade defamation or interference with economic relations, and was awarded damages as a result of that overly aggressive demand letter. So some care needs to be taken in asserting, much less enforcing these rights. Next, I think, and last slide. So here's a few things we've learned up in Canada in this process and working in this area. Obviously, if you can get a utility patent, that's often a better weapon in your IP arsenal, and you should. It isn't hard to get these designs registered, and they can be helpful assets, but I think clients need to think long and hard about the costs of enforcement and the prospects for success before litigation commences, particularly where there's utilitarian features and a lot of prior art. It isn't hard to design, as Mackenzie said, it's not hard to design around a competitor's registered design because small differences matter. And so we see a fair bit of that happening where a client will say, you know, we have a competitor who's doing this, we like that, can we do it like this? And it doesn't take a lot to make changes that will avoid infringement. The last point, which I think everybody should consider, is that a unique and distinctive product design is very often a better design, because passing off in trade dress claims against lookalike consumer products in particular can be a better and safer option in litigation, where the issue is really, do you have a reputation in association with this? Is the sale of something else causing confusion in the market? And are you likely to suffer some damages? In our experience, that's an easier case to prove at trial without getting into prior art and functionality and utilitarian features. I think it's easier to prove confusion amongst consumers than it is to prove substantial dissimilarity or similarity to a judge. So those are the views from Canada. We've got about 5 minutes left. So if anybody has any questions, we'd be happy to entertain them now. And while we await that, Mackenzie, Voss, and I would like to thank everybody for their time and attention today. And again, pleased to answer questions now or to receive them afterwards by email or any other means. Thank you.
Thanks, Jim. I think we have one question here from the audience. The question is, how long does it take to obtain a design patent versus a utility patent? So in the US, design patents from start to finish, this is from the time of filing to issuance, you'll get them within sometimes less than a year, sometimes it will take 12 to 15 months, mainly because one, they're picked up a lot faster compared to utility patents, and two, the prosecution timelines are a lot quicker as well. And just comparatively, start to finish for a design patent is 12 to 15 months. Start to finish for a utility patent can be anywhere from 2 to 5 years, because the backlog at the patent office for utility patents is a lot larger. And by the time you receive your first office action, it can be anywhere from 1 to 2 years itself. Add on prosecution timeline, and that's where you get the 2.5 to 5 year overall length from start to finish for utility patents. So if there's an opportunity to seek design patent protection, I would always recommend doing it, just because one, it can be part of an overall IP strategy where it's quicker to obtain a design patent, and it's also cheaper to obtain a design patent compared to utility.
We've got a few more questions, but only a couple of minutes, so we'll try to respond to them if we can. One is whether design patent litigation is more or less expensive than utility patent litigation, at least up in Canada, and then I'll defer to Mackenzie and Voss. I think it usually is. But again, I think it depends on the utilitarian aspects of the particular product. I think they're probably cheaper cases to have dismissed, but sometimes equally expensive to successfully enforce.
Yeah, I mean, the same can be said in the US. And additionally, design patents are often asserted in parallel with the utility patent in the same case. And so a lot of times, it'll all get rolled into the same action. But I think if you were truly, kind of discreetly looking at a design litigation versus a utility, overall, it's likely to be less expensive. But again, there are certainly circumstances that can make it just as costly.
Another question, and Mackenzie and Voss, you might have views on this, but how do I decide where to bring an enforcement action? You touched on this, Mackenzie, so perhaps I'll turn that over to you.
Sure. I mean, I think it really has to be case by case, depending on the industry and what the target or the competitor or the infringer is doing and where they're based. So, you want to see where you can get jurisdiction over that party, of course, and where you actually have design rights. That'll be the initial inquiry to kind of narrow it down to those jurisdictions. And then beyond that, you may want to start considering cost considerations. Would one jurisdiction maybe a lot cheaper than another with respect to that litigation in general? And if so, could it be just as effective? So if you're, like I mentioned during the presentation, if you're cutting a supply chain off, early up the chain, then that might be a good place to target. So
yeah, and I would just add there, Mackenzie, and we'll answer the other questions if we can in writing, that different jurisdictions take different views on the strength of these designs, and very often there is a global supply chain. So it's important to also look at where are your best prospects for success, what jurisdiction is most likely to uphold your design and find infringement, because a decision in one big jurisdiction may inform whether that product still gets made and sold in other jurisdictions. So we're at the top of the hour exactly. Thank you, Mackenzie and Voss, and thank you in particular, everyone, for joining us. We've just popped up the CLE attendance code, so we'll leave it up there for a minute or two so you can jot that down. We do very much appreciate your time and attention, and hope you all enjoy the rest of your morning, day, or evening.